Hi, my name is Leo Kishinevsky. I'm a personal injury attorney here in Houston, Texas, and founder of the Kishinevsky law firm. I've been a practicing and licensed attorney for about 15 years. The vast majority of that time I've spent working on personal injury cases and representing clients who have been injured. One of the most common and most important questions that we get as personal injury attorneys have to do with the statute of limitations. What is it? How does it apply to somebody's case? The statute of limitations is basically a deadline that starts running the moment that a car accident happens or another event causing an injury happens. In Texas, the vast majority of personal injury claims are brought under a negligence legal theory, meaning the person or the company that caused the accident or the injury was not acting in a reasonable manner. Negligence normally has a 2-year statute of limitations. What that means is if a lawsuit is not filed or a case is not settled by the 2-year anniversary of the date that the injury happened, that person legally their entire claim can be thrown out of court because they waited too long to try to seek relief and take advantage of the legal remedies that are available to them. In other words, it is a hard and fast deadline. As with anything in the law, there's always some exceptions and ways to try to get around it if certain facts apply in specific circumstances. But the most important thing about the statute of limitations is basically for everyone to know that it's out there, and there's not a single situation where someone's personal injury case is going to get better by just waiting there and not taking action on it. When someone's injured, especially in a serious injury situation, it's often overwhelming, it's emotionally devastating. There's a million things coming at them from all sides that they're trying to deal with, and it can seem mentally daunting to, on top of all that, do the work of trying to look for an attorney. But because of the statute of limitations and a lot of other factors, it is very important that if someone is injured and someone else was at fault in causing the injury, the injured person uh, start looking for an attorney and seeking legal help and finding out about the options that are available to them sooner rather than later, because the statute of limitations is going to be there before they know it. And in the meantime, the longer they wait, the more phone records and videotapes get erased, memories fade, information gets lost or destroyed in the course of time, evidence is harder to locate. So there are a number of other reasons besides the statute of limitations to try to act as quickly as possible if you've been injured due to someone else's fault. If you have any questions about your specific situation and you want to get some more information, please contact our office at 832law.com.
Talk statute of limitations. This is Rashmi with the Kishinevsky law firm. I am the managing partner at our firm, and we predominantly handle personal injury claims here in the Houston metro area and beyond. Statute of limitations, very important. In summary, you have 2 years to bring a personal injury lawsuit. Just 2 years from the date the incident, car wreck, or injury has happened. Or in some cases, there might be a minor leeway the moment you become aware of an injury. Now, there is an exception to this 2-year rule, and there's several, but we're going to focus on the main one we see day to day. Does the injury involve an injury to a minor child or someone under the age of 18, essentially? There is something that we call tolling. What that means is, let's say a 15-year-old gets into a car wreck. The 2-year statute of limitations does not apply to them because they do not have capacity to bring their own lawsuit. Now, generally in these situations, there is hopefully a parent or guardian that can step in these situations, and we call it, filing as next friend. start that process, because we never want to delay a, legal action when there's an injury involved for various reasons, which we'll explain in another video altogether. However, let's say for whatever reason they need to bring a lawsuit themselves and they're unable to. It's kind of unfair by state law to have someone who, by definition, may not have full capacity under the color of the law, to not be able to bring a claim timely. And so what happens is their statute of limitations is told or delayed or paused until that minor reaches 18 years. And then the 2-year clock starts ticking. So if a 15-year-old gets into a car wreck, they have essentially until they're 20 years old, so 2 years after they turn 18, to bring that legal action. This is a way to protect minors who've been injured, until they're able to, hire an attorney and bring that claim themselves. Now, in general, though, we do advise, if there is a parent, if there is a legal guardian, that we try to file these lawsuits even when the minor is still a minor for various reasons. First and foremost, the preservation of evidence, right? Memory of witnesses can fade. Depending on the evidence, whether it's photographs or documents or, certain medical injuries, we want to bring it all when it's fresh. So it's really important that even if there is tolling in the case of a minor, that if possible, give an attorney a call, get that claim on file with the courts ASAP. And you can, if you have any other questions, if you are someone who's a minor who's been injured, or a teenager who's been injured, or let's say you're a parent of a minor that's been injured, specifically, if you want to know more information, you can always reach out to us online at www.832law.com, or you can also call us at 832-LAW-1111. Our phones are open 24/7.